I want to talk about prenuptial agreements. And in preparing for this video, I started doing a little bit of research on the history of prenuptials. When I started dating about 10 years ago after my divorce, my daughter gave me some advice, and part of it was when dating women, don't talk about birds or history. Fortunately, the woman that I married in 2016 likes birds, but history is still a bit iffy. So I wanted to talk about prenuptials, and historically, it's fascinating. Prenuptials go back 2,000 years, and they relate to issues like dowry, coverture, and one of the topics that comes up with the earliest form of prenuptial agreement is the Ketubah in the Jewish religion. And in doing this research, I found out about something called the Married Woman's Property Act of 1848 in New York State. It turns out that the first law that gave a woman the right to control the transfer of property took place in 1808 in Connecticut, which meant that she could control the transfer of property through her will. But it wasn't until 1839, interestingly, in Mississippi, and then 1848 in New York, that women's property rights, and specifically married women's property rights, started to be recognized. The idea of coverture, which is a common law concept, is that once a woman marries her husband, all of her property rights are essentially subordinate to the husband, so that the husband would have the ability to control all aspects of the wife's ability to enter into contracts, to hold land, etc. And in 1848, apparently because of the work of some women that we are all familiar with, Elizabeth Cady Stanton, who was studying law in her father's law office in upstate New York, and Susan B. Anthony, really the template for providing married women property rights was enacted. And I could read you some of the wording. It's just a 4-paragraph statute, 4-paragraph law, but it was really the beginning of the modern feminist movement. And the fact that it took place in 1848 is consistent with the significant convention for women's rights that took place in Seneca Falls, New York, also in 1848. So we take many things for granted, and it's just very interesting to see a statute like this and thinking about the spectrum, the legacy over time from 1848 to women getting the right to vote, and I believe 1918, 1919. For me, it was hard to wrap my brain around the fact that women did not have these rights as at that time, and that it was really necessary for all of this legislation. And it makes you appreciate the fact that all of this legislation is absolutely necessary to bring all of us up to par in terms of our legal rights. So history is important. Prenuptial agreements are very important to control what happens with your property in the event of divorce. It gives both parties the ability to exercise more control and to avoid court, to avoid costs, to avoid aggravation. So if you need help or have questions concerning a prenuptial agreement, please contact me, Kenneth Novenstern, Fredman, Baken, and Novenstern in Mount Kisco and White Plains, New York. I look forward to talking with you.